Ghislaine Maxwell's multi-million-dollar defense team finally filed their motion for a new trial. Look at that. And it is thick. It is 66 pages. We're going to go through it today. Not all 66. You don't want to listen to me read law and argument, but there are some juicy bits. Juror number 50 comes back at the forefront. We're going to see this is the case we've been following, United States versus Ghislaine Maxwell. We know that this was filed on March 11, 2022, so it's brand spanking new. Been waiting a long time for it. We know that Jeff Paliuka, Laura Menninger, Christian Everdell, and Bobby Sternheim were the four people making up Ghislaine Maxwell's defense team, and they were raising issues all throughout the trial, all even during the before the trial, during pre-trial. They were flagging every single potential issue because they knew that they were going to be preparing this in the event of a loss. And so let's take a look at it, just sort of take an understanding of what the big chunks are in this motion. This is Ghislaine's defense team saying she deserves a new trial. There were serious problems with the first trial, constitutional deprivations, due process violations. She didn't get a fair and impartial trial like she is afforded or guaranteed to be afforded under the Constitution. And so we need to do this whole thing over again because we cannot trust the outcome. And so let's take a look at how they broke this down. We see the first main crux of this thing is all going to be about the factual background. So they're going to give us some details. They're going to say, look, Judge, here's what you need to know before you're able to make a ruling. This is sort of our perspective, our version of the events, and this is why this is problematic. And of course, what do we see here? A lot of Juror 50. We've got the questionnaire, we have the voir dire, and then we got the final composition of the jury. And they even have a problem with the questionnaire in general. So the jury questionnaire. So you can see in this first section, a lot of sequential kind of problems. A big problem, apparently, we're going to see with the jury questionnaire. Then that questionnaire was filled out incorrectly by Juror 50. Then when he filled it out incorrectly during the time of voir dire, when they're asking him individual questions, problem with that. And that means the entire jury is compromised. So you can see how it's go bop, bop, bop. It's sort of like follow the bouncing ball into the next sentence. Then we see under subsection 2, Juror 50's admissions, right? He admits it. Yeah, look, I wasn't truthful to the court. Turns out I was a victim of these things. And I even admitted it and acknowledged it in these multiple conversations with these multiple media entities, the Independent, the Daily Mail, Reuters. And this was Juror 50, Scotty David, going to these media companies and saying, hey, look, I want to talk about this. I was in fact a victim of the same type of misconduct, the same type of criminality. I didn't report it, but I was the victim. And so I used sort of that experience to guide my decision-making process as I was sitting there contemplating the fate of Ghislaine Maxwell. And of course, we talk about this, right? How can somebody who is a victim of something so traumatic and catastrophic really be fair and impartial if they're sort of, judging somebody who is facing those same accusations? And I think, both sides agree on this largely, which is why prosecutors are, allow that question to be asked of potential jurors, because even, they know, they're like, all right, that person went through something like this, probably is not a good candidate. And so, they identify those people and help remove them from the jury panel, not because they're bad people or because of anything problematic, but because of the sensitive nature of the criminal allegation. So they have issues here, and they also are taking a look at his social media activity. And then under subsection C, they're identifying even a second juror who admits to disclosing that they too were a victim of this type of abuse when they were on the jury, before they got on the jury panel, but it wasn't properly disclosed prior to them being seated. So a lot of interesting facts. We'll take a little bit closer look at some of those. We have the applicable law. We've got Juror 50. Now, the misconduct now is the law. This is the section where they're going to be saying, look, Judge, we know what the facts are. We need to talk about the rules, and then we're going to make argument based upon the rules. And so in law, what we talk about this, the format is called IRAC, not like the foreign war that didn't work out so well for anybody. We're talking about IRAC, the issue, the rule, the analysis or the application, and then the conclusion. And so you can see here, we're sort of in the application or the rule section here. What is the law? What is the rule that we're going to be guiding under or applying to the facts? And then we're going to see argument based upon that. So we've got the issue that are brought up under the facts, the rule, and then we have the application and the law. So here, applicable law. Juror 50's misconduct deprive Maxwell of her constitutional right to a fair trial by an impartial jury. And we already spent some time on that, right? We talked about this. If somebody has been the victim of a crime, something so catastrophic as this type of abuse, it makes it difficult, according to many people who have much more qualifications than I do, to support the idea that they may not be able to be fair and impartial. They say under subsection A party alleging unfairness based on undisclosed juror bias must demonstrate first that the juror's voir dire response was false, and second, that the correct response would have created a basis for a challenge. Okay, so in other words, what this is saying is if juror number 50 had properly answered that question, if he had checked yes instead of no, it would have triggered basically everybody in the courtroom to go, oh, well, we better ask him about that and really dive in on that. Okay, juror 50, are you sure you can be fair and impartial? We're going to talk about the same. So what happened with you? Okay, got it. We're talking about that same thing, and you're going to see pictures about that, and we're going to see allegations, and other people are going to come out and talk about this and cry and break. Are you sure? Yes, I'm positive. Okay. Right. And so then you'll have the defense that would obviously strike that person for cause, and the judge might even have done, but there was no opportunity to do that because he didn't correctly answer the form. And that's what they're saying. B says unintentionally false answer during voir dire is not a prerequisite to obtaining a new trial. So intentionally false is not. Now here they say the argument. So they're giving us a couple rules. Then they're going to apply the argument. They say Maxwell's entitled to a new trial. Obviously, they're going to say that. And they say juror 50, why did not answer truthfully material questions during the question session, which is voir dire. Had juror 50 answered questions 25 and 48 correctly, his answers would have provided a valid basis for a challenge for cause. Why? And they give us 3 reasons. Actual bias, right? He's actually biased. Inferable bias, or people can say, well, he may say that he's not, but kind of infer that based upon what happened to him. And also implied bias, and we're going to break those down. We'll run through this all quickly. Again, it's 69 pages or 66 pages, so we'll take a look. They say subsection C, juror number 50's answers were intentionally false, so he was sort of materially problematic, but he was doing it intentionally. So the question was a big problem, and it was intentionally crafted as a response in order to put him on the jury, I think is what the argument's going to be. Had juror 50 answered them truthfully, they would have explored other answers that he gave and seen whether those were false. They're talking about the scope of the hearings. They're saying juror number 50 didn't even have a right to be involved in this, Judge. You brought him in to question him, shouldn't have even been here. He had no right to intervene. He had no standing at all. And this court should actually refuse his discovery request because he's under investigation. He's not a party to this case at all. In fact, he is somebody who intentionally violated his honesty. He said he was signing that form saying, I promise under the penalty of perjury, I swear under oath. This is all true. And he didn't. So why is he given discovery and being participatory in this conversation is what the defense is arguing. And then we see juror number 50's filings should be stricken or remain under seal. Then we get a conclusion. The conclusion, of course, will be Ghislaine Maxwell should get a new trial. And now we can take a look at the substance. Here you can see that Ghislaine Maxwell's multi-million-dollar defense team, they're going to give us the table of authorities, and they have a lot here. And a lot of this, let's see where some of this comes from. The Supreme Court, 2nd Circuit, 10th Circuit, another Supreme Court case. And so they're just kind of bouncing around the circuit, 7th, 2nd. We've got the Northern District of New York. Let's see what else. More 2nd Circuits. A lot of cases. You can see it just keeps going, 2nd Circuit to 9th Circuit, a lot of the seconds. So it's sort of in the area where the Southern District of New York is, right? A lot of Supreme Court cases. Supreme Court will cover all the different jurisdictions throughout the country because it is the Supreme Court. But then we also have all the 2nd Circuit, 3rd Circuit, which are all up there sort of in New York, that covers New York and that area. We've got constitutional amendments and the federal rules of criminal procedure that are violations. And then we see some of the introduction. And see, it starts right out with the key phrase. We've got juror number 50. Juror number 50, Scotty David, says he was the victim of this type of abuse, and apparently he told his jurors this, according to Maxwell's defense. He said this apparently. The room went dead silent. Juror number 50 told several media outlets that he drew on his personal experience as a victim to persuade fellow jurors to believe Miss Maxwell. They say that was unfair and prejudicial. Should have told the truth during voir dire, during the questionings, but he didn't. Filled out the form wrong. Didn't answer the questions honestly. Said he repeatedly and unequivocally denied having been the victim and had multiple opportunities to be honest about it. Had he told the truth, he would have been challenged and excluded for cause, which is true, which is absolutely true. Sixth Amendment guarantees trial by jury. Fundamental to a trial by jury is the guarantee that 12 dispassionate individuals would be able to fair and impartially decide this case. Voir dire, which is the questioning phase of a case, is critical. It plays an essential role in this. And how can you have a fair trial without that? They say that didn't happen here. Juror 50 did not truthfully respond to his questions. His false answers undermined voir dire, and they deprived Miss Maxwell of her constitutional right to a trial by jury. Then we get the factual background questionnaire. And we talked about some of this. You can check out that video up in the corner. Here you can see a jury questionnaire went out, 22 pages, 50 questions, given as much time as they needed to complete these. But Scotty David said he just flew right through the whole thing. Questions began with a summary. Question 13 asked potential jurors if you can decide the case. Question 42 is when we get some of the conversations about this type of assault and abuse. Question 42 specifically asked whether the allegations against Miss Maxwell, quote, might make it difficult for potential jurors to be fair and impartial, which is an obvious question for something like this case. Question 43 asked potential jurors if they've got questions about laws concerning the age of consent. 44 asked jurors if they had views about those types of laws. 47, do you have difficulty assessing the credibility? And then we get to other questions. Prior to finalizing the question, Miss Maxwell proposed specific questions to jurors, okay, so off of the questionnaire. The defense asked or proposed to ask potential jurors whether or not any one of you have been a victim of this type of abuse, whether or not any one of you, similar question. The government objected to those questions, said you can't answer those. And the court partially agreed with those people. Oh, well, that's interesting because the defense is going to say, had we been able to ask the question that the prosecution objected to, Your Honor, and had you allowed us to ask the questions that we wanted to, Your Honor, we would have found this problem. But you didn't let us. And so now what we need to do is do this whole thing over again because it's been tainted and corrupted. They say here specifically, question 48 asked, have you or a friend or family member ever been the victim of any of these things? The questionnaire offered 3 answers: yes, yes, friend or family, and no. If a potential juror selected either yes option, the questionnaire asked individuals to explain their answer in writing. And if so, to explain why, if this could be something that would impact their ability to be fair and impartial. And then question 50 asked potential jurors if there was any experience that might impact, any experience, right? Any experience that they just could think of, whether it might impact their ability to be fair and impartial. And so juror number 50 then says here, question number 13, juror 50 says, yes, I can decide without any bias. Question 25, no, never been the victim. Question 42, no, nothing about the allegations that might make it difficult to be fair and impartial. Question 43, juror 50, no, did not have any views about laws concerning the age of consent. Question 44, no, juror 50, no views about laws governing these types of things. Then we have 47. Juror 50 writes, no difficulty assessing the credibility of any of those victims. And then finally, and most importantly, juror number 50 answered no on question 48. Have you ever been the victim of sexual harassment, abuse, or anything else like that? He says no. Now, prior to the trial, the defense counsel moved the court for limited attorney-conducted voir dire of the potential jurors so that they could ask them additional questions, another layer of questions. Counsel said, listen, Judge, because of the allegations involved in this case and the stakes and the media coverage, an attorney-conducted voir dire to supplement the questions that you're going to ask, Judge, the court's voir dire is necessary to make sure we can get a fair and impartial jury. Defense counsel, when they were making their arguments, and I think we talked about this, specifically pointed to certain jurors that could not be fair if they were the victim of a crime. And guess what happened? Darn it. The court declined to permit attorney-conducted voir dire. The judge got to ask the questions, and so the defense didn't get to raise these issues. Prior to trial, defense counsel also proposed to the court to individually ask each juror in person several questions, including, have you, anyone ever close to you, been the victim of a crime? How about a different type of crime? Government objected, said, nope, already asked those during voir dire, already put those in the questionnaire, already included those. They shouldn't be asked again. The defense responded in part saying that, quote, asking the questions live when the jurors' reactions, their hesitations, and their explanations can be explored by the court and observed by the parties will aid in the selection of a fair and impartial jury. So even though they might have filled a question out, the defense wants to take a look at them and say, have you ever been the, oh, okay, all right, well, I believe that one. You, I'm not so sure about you, though. Why'd you kind of fidget in your chair over there? How about you? Right? And there are attorneys, there are expert witnesses and people who sort of observe these things for that specific reason. And Ghislaine Maxwell could afford those people to be on the panel. And they, in fact, actually did have somebody who was there, and I'm not sure how involved he was because of some of these rulings. The court, as we can see, denied the defense's request. Juror 50 appeared for voir dire on November 16th, and because he answered no to all the questions, his actual questioning was very brief, just 7 pages. That's it. The court did not ask any of these questions about whether abuse he suffered would make it fair or make it difficult for him to be fair and impartial. Didn't get to explore that issue because he marked no. As to the questions the court did ask, most of which address his personal background, he wasn't even truthful about that. For example, the court asked Juror 50 if he used social media. He said, I recently ended a relationship, so he, quote, deleted them and was, quote, fully off it right now. That was at page 133. Asked, quote, what do you use? Facebook, Twitter? He said, I used Facebook and Instagram, but did not mention any Twitter account. Juror 50 said he deleted all of his accounts the week before. Well, they write, in fact, Juror 50 had a Twitter account created in April 2021. Kind of right before the trial. Said that he did not delete. He used the account to tweet about the interviews he gave following the case and to communicate directly with Annie Farmer, a victim who testified. It appears that Juror 50 did not delete his Instagram account. Liar is what they're saying. Despite what he told the court. Liar. They're saying since he posted about his jury service after the verdict was returned. At the end of a very brief line of questioning, Judge, the court asked Juror 50 if, quote, he had any doubt about his ability to be fair. You have any doubts about this? He said no. Court said, okay, well, other than what I've asked you today, do you have any reason to think that you can't be fair and impartial here? Any reason? He said, I do not. So there's like 7 opportunities for this to come out, and it didn't. That's why there's 7 opportunities to make sure it comes out. The court inquired whether the parties had any follow-up questions because Juror 50 denied any bias or any ability to be impartial, and because his answers on his questionnaire did not raise any of the red flags, we couldn't ask him questions. The lack of follow-up questions for Juror 50 contrasts with other jurors who honestly disclose their history. Other people check the right box, and they ask them questions about it. And presumably they didn't make it onto the panel. Also, the lack of follow-up questions put to Juror 50 contrasts with Juror 55, whom the court struck for cause because why? Redacted, right? Protecting the information of Juror 55. But presumably what they're talking about is they're saying, hey, Judge, when another person that we were sitting through doing voir dire with put yes on that question mark, we asked him all of these questions and we said, can you be fair and impartial? And they said whatever they said there, and we booted them anyways for cause. We would have done the same thing with juror number 50 had we had the proper flag, the indicator. Here, this continues. We see the final composition of the jury panel, only on page 9. We're going to skip through a lot of the meaty chunky legal stuff. But here you can see the final composition of the jury. 694 jurors answered the 50 questionnaire. 694 potential jurors answered the 50. That's a lot. That's a lot. We have here bullet points we can't see. None of those bullet points, totally redacted. Of the five, and so what they're probably talking about here are the different types of jurors that came up and were booted, right? They're probably, juror 37 was some issue, blah, 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 and he got booted. Juror 227, marked no, and went through and did that. And so you got a whole list of what those are. Of the 5 jurors seated as alternates, none disclosed on the questionnaires that they were victims. Of the 12 deliberating jurors, none disclosed of their questionnaires that they were victims. As we now know, however, Juror 50 was not telling the truth when he denied being a victim. As explained below, it appears a second deliberating juror was also untruthful when they denied being the victim of sexual. And they say here, we got a whole redacted paragraph, can't even see it. Now we go through the different interviews, and we've talked about these many times. First of all, Juror 50 gave an interview with The Independent, and he's talking, it sounds like, with this woman, Miss Osborne Crowley. Yeah, that's who he was being interviewed with. Said, according to Juror 50, he said, quote, the jury room went dead silent as soon as he shared his story. Relying on his own experience, he refused to credit the testimony of Loftus, saying that Juror 50 explained all of this to the jury. Said Miss Maxwell's accusers were all believable. Said nothing they said felt to me like a lie. He said sometimes, you can misremember trivial details of a traumatic event without doubting the core of the memory. So none of the testimony, he said, related to traumatic memory. So he was being an expert because he's been through this. Juror 50 also explained, again, based on his personal experience, why it was immaterial to him and the jury that the alleged victims did not disclose the alleged involvement until very recently. He said, I didn't disclose my abuse until I was in high school. So he's using his prior experience to influence this. Juror 50 also had an excuse for why the alleged victims in the case kept going back over and over. In Juror 50's view, Maxwell's defense team continually attacking the victims, trying to get the jury to judge them for the decisions, is what he said. So then he goes and he gives an interview. On January 5th, the Daily Mail published an article. He said that she was a predator and said, from his point of view, you can't remember all the details. When Juror 50 told his fellow jurors of the abuse he suffered, he said the room went silent. And he said that the verdict was, quote, for all the victims, right? So now we have sort of an advocate. We have somebody who is not weighing the facts in front of them for the person in front of them. They are doing this for a cause. This is something that is bigger. It's sort of for something that exists outside the courtroom. And you can do that type of stuff outside the courtroom, but not inside the courtroom. That's when you're rendering a verdict based on the facts and the law in front of you. We have an interview with Reuters. He gave another one. According to Juror 50, coming to a unanimous verdict wasn't easy, to be honest. He said, several jurors doubted the credibility of Jane and Carolyn, but he said, when I shared that I was a victim here, the jurors who had doubts were sort of able to come around on it. They were able to come around on the memory aspect of the abuse. And they're probably in a very awkward position to say, listen, here's what I think about memory. And since, I disagree. I think that somebody would remember that, but I'm not a victim. And he said, well, I am a victim. And so how do you know better than I do? And you go, I guess you're right. And so you get this sort of public pressure, and then you get people to fold. Now, that's sort of what happens in a jury deliberation room anyways, right? People are having to come to discussions on difficult topics and reach a unanimous verdict or not. So this type of pressure comes in, but we try as lawyers and judges and courts to make sure that those deliberations are as fair and impartial as possible by keeping those biases outside of the courtroom. We have another subsection here, paragraph 4, the partial video of the interview with the Daily Mail. And there's a lot here. He says he denied being asked the questions. He said, no, they don't ask your abuse history. They didn't ask it in the questionnaire. Yeah, they did. We went through it. Something that he said yes to in the questionnaire was something people were aware of when he was selected as a juror. And the answer is no, they were not aware of that. Otherwise, you would have been booted. The interviewer challenges jurors and saying, hey, I thought that there was a questionnaire. It was number 48. He said, interesting. He said, my face is red because I know that it was it was something that maybe I skipped over. I don't remember it being there, but I was honest about this stuff. Then we go on social media. Accordingly, on Miss Farmer, says here apparently, on January 4th, after Miss Osborne Crowley first published her interview with Juror 50, Annie Farmer tweeted a tweet from Miss Osborne Crowley linking to the interview. So Miss Lucia Osborne Crowley was the person who interviewed juror number 50, Scotty David, and said, reading this, I was overwhelmed with a sense of gratitude for this juror who was brave enough to disclose his own trauma to help others understand the experience. For the other women who testified, for my sister and the other survivors, kept pushing for justice. She's very happy about it, acknowledging that his story might have been enough to persuade the other jurors to come to a verdict of guilty. Juror 50 then tweeted directly to Miss Farmer in response. So he kind of knew that this was going on, not on social media, but tweeted, and says, thanks for being brave enough to stand up and share your experience, Annie. Your story was critical in how we reached our verdict in that jury room. Thanks for sharing my story. Juror 50 also liked that, says Ghislaine's defense team. Juror then 50 tweeted to Miss Farmer. His Twitter handle was the same name he used as the press interview, Scotty David NYC. Change that handle over there. Shortly after tweeting, he changed his Twitter handle to NYCSSDDD. And then he attempted to delete his tweet to Miss Farmer. Well, why did he do that? That's pretty interesting. So he gets on there, tweets, and then changes his handle. See what happened there? NYCSSDDD. This tweet has been deleted. Juror 50 did not unlike Ms. Farmer's tweet or the tweet by Crowley. In earlier January, Juror 50 also posted about his jury service on Instagram, despite having told the court during voir dire that he deleted that account. Here he is. This bear travels on Instagram. Says, I can now tell everyone that I was a juror on the Ghislaine Maxwell trial. Been incredible, surreal experience. This state does not offer therapy, unfortunately, but I see a therapist regularly, so I've had some help dealing with the stress from this case. We thank you from throughout the world for your brilliant service. And got some photos there. So if it is possible, Juror 50 deleted his Instagram account before the trial, as he told the court, and then reactivated it. We don't know. Shortly thereafter, Juror 50 deleted the Twitter account and Instagram, also Facebook and LinkedIn. A second juror admits to disclosing some of this stuff. During his press tour, Juror 50 revealed in interviews he was not even alone, that other jurors were also revealing this stuff. Said a second juror also disclosed that they were a victim. On January 5th, New York Times published an article confirming that, saying a second juror described in an interview having been abused. The juror who requested anonymity said that they too discussed their experiences during deliberations and that the revelation appeared to help the jury's discussions. To date, the juror has not publicly revealed their identity, and Ms. Maxwell does not know who it is. Curious. Now, under subsection, we got a footnote 10 here. Don't know anything about that. Of course, we can see here. Would be very interesting to know a little bit more about that second juror. But the court doesn't know, and we don't know if Scotty David knows. We don't know if the court is going to inquire. So then we see some of the applicable law, and they're going to tell us Juror 50's misconduct deprived Maxwell of her constitutional right. And you can see a lot of this stuff gets pretty thick. So we'll just take a quick look through it. Sixth Amendment guarantees right to a trial by impartial juror. We're going over to Southern District of New York, talking about voir dire playing an essential role in protecting rights. Defendant doesn't need to demonstrate prejudice when a juror gives a false material question if the juror would have been subject to a challenge for cause if he answered honestly. All right, so see that's a pretty key sentence here. This is a U.S. Supreme Court case. A defendant doesn't need to demonstrate prejudice when a juror gives a false answer to a material question during voir dire if the juror would have been subject to a challenge for cause if he answered honestly, right? So what this is saying is if Juror 50 had answered honestly, he could have been booted right then and there, according to the defense. They're citing a U.S. Supreme Court case, Martinez Salazar, that is saying they don't have to show sort of actual prejudice. They just need to rewind back the clock. In other words, they don't need to show that Ghislaine Maxwell was actually harmed. They just say that had we rewound this clock a little bit and had he answered correctly, we could have booted him at that moment for cause. That's it. We don't need to show that he actually prejudiced or biased the trial, or that his conversation in the deliberation room caused something unfair, and none of that matters, is what they're saying. We could have stricken him for cause had we known. We didn't know. It was material on a material question. That's it. They're saying here, when a biased juror deliberates on a jury, structural errors occur and a new trial is required now without a showing of actual prejudice. See Arizona shout out versus Folamonte, U.S. Supreme Court case. Couple of good cases there for some good case law there. And then we're going to see subsection B. An intentionally false answer is not a prerequisite to obtaining a new trial. So they're saying, look, he didn't have to intentionally lie in order for this to justify a new trial. It doesn't have to be intentional. It could have been mistaken. It could have been, a lower standard. If it was intentional, certainly that might justify it, as they're going to say, but they don't need to make it intentional. They are going to say it was, in fact, intentional, as we saw in the table of contents. An intentionally false answer during voir dire is not a prerequisite to obtaining a new trial. We can see this continues on. Let's skip some of this here. There were two concurring opinions in another case called McDonough. The Second Circuit adopted the reading of McDonough, endorsing the view by Justice Brennan that an intentionally false answer is not a prerequisite to obtaining a new trial. So you see what the law is in the Second Circuit. Argument, Ms. Maxwell gets a new trial. Juror did not answer truthfully, which is true. Had he answered truthfully, would have been a basis for cause. Implied bias means bias conclusively presumed as a matter of law. It is attributed to a prospective juror regardless of actual partiality. Okay, so a lot of heavy case law here. You can see a couple paragraphs of this. So we're going to go through. We'll see what the conclusion here. Okay, here we got some. The similarities are profound because they bear on the principal argument Ms. Maxwell made. They were corrupted and unreliable. Juror 50's claim that the memory of his abuse can, quote, be replayed like a video is perhaps most significant because it directly contradicts Loftus' expert testimony, right? So what's happening here is we have somebody who's qualified, according to the court, to be an expert witness on these matters, somebody named Dr. Loftus. We listened or read some of her testimony when she was testifying in this case. And there's a process that she goes through to become an expert. You don't just pull somebody up off the street and say, do you know about lungs? Yeah. And okay, come in and testify. You have to have years and years of experience, be subject to cross-examination. And it's a complicated process because you don't want non-experts LARPing, pretending to be experts. The jurors are not supposed to bring stuff in from external expert analysis or external sources because that stuff has not been vetted. Here, what he's saying, or what the defense is saying, is that juror number 50's recollections were in direct contradiction to what Loftus was saying, and he's not a qualified expert on this subject. Memory, they write, has been termed a consecutive process, right? Yes. Can you explain what that means? She says, look, what we mean by that, as I said earlier, we don't just record events and play it back later like a recording device, like a video machine. She says, we construct our memories when we retrieve memories. We take bits and pieces of experiences, sometimes that occurred at different times and places, and we smash it all together. Given Juror 50's personal experience, there's no way he could fairly evaluate Miss Maxwell's challenge to the credibility of her accusers or the expert witness testimony. He's not qualified to do that. Several decisions support the conclusion, as we can see, and we just keep going. A lot of sort of heavy citations here. The bias of Juror 50, we're still on implied bias, so we're going to go down to inferable bias. This exists when a juror discloses a fact that speaks to a risk of partiality. A little bit different than implied. It's now inferred because of something that they have done. Here we can see, moreover, continues on and on. We got some examples. Actual bias, obviously, right, might be here. A juror is found by the judge to be partial because he either admits it or he finds actual partiality based on the answers. Actual bias is based upon express proof. The court doesn't need to answer whether he was actually biased, since the court can and should infer bias. Assuming this court holds an evidentiary hearing where he's compelled to give answers, Ms. Maxwell reserves the right to argue that he was actually biased. And they're saying he was intentionally lying, right? He was intentionally false. 6 reasons to believe why Juror 50 lied intentionally. They say, first, this court only has to watch the video when he's confronted with his false answers to see what happened here. His face flushed, turned red. He grasped for words. When the Daily Mail reported him, he said, "Oof, interesting." He said, "No, I know my face is red. I can feel the blood, but that's why I answered it that way." They write, second, attempted to falsify his answers by claiming he flew through the questionnaire. The questionnaire said, you have to carefully complete this. There was no time limitation. They were advised multiple times. There were no right or wrong answers, only truthful answers. We talked about that. The court must presume Juror 50 heeded these instructions. And this fly through stuff is nonsense. That's all after the fact. He's making it up. For example, he correctly skipped through the questions that he didn't need to answer if he answered no, right? And we talked about that. When we went through our video of his questionnaire, we said he got that one right. That's a complicated question. Got that one right. That's a complicated question. That's weird. Why is he reading all of these thoroughly and getting them all right? And then moving on to the next one, it just got the one that if he answered it honestly wouldn't put him on the jury. Why did he skip that one? Third, it's simply not credible that he's not going to remember a question like that. This is a case involving this subject. The whole case is about this subject. There's going to be a question about that. Juror 50 said he did remember the questionnaire asking about his friends or family, but not about him. Oh, I thought it was only about other people. I didn't know it would apply to me. I thought that, I didn't know it would apply to the actual juror who's going to sit on the panel. So we see there, 4, Juror 50's post-verdict conduct shows his false answers were intentional. He went on the media to promote himself, use his experience as a victim, use his role on the jury. He went hog wild out there, went to the Daily Mail, went to Reuters, all over the place, gave multiple interviews to several different outlets, sat for an interview, part of an hour-long documentary called Ghislaine, said he engaged on Twitter with Annie Farmer. Very excited about this. His publicity tour appears to have stopped, they write, at least temporarily, only because the government publicly filed a letter asking the court to investigate his truthfulness. Otherwise, he probably wouldn't have stopped talking. Ooh, this is pretty tough. They say Juror 50 was clearly enjoying his 15 minutes of fame in early January, giving multiple interviews, congratulating himself. The government recognized that he dug them a very deep hole. The prosecutor saw this and went, darn it. And the hole looked like it kept getting deeper. Without conferring as to either the submission or the letter or any redactions, the government publicly filed docket 568. And we read that one. That's where they said, sorry, judge. We just learned that this Yahoo was out there giving interviews that might have wrecked our case. But you're going to hear about it because these are being published all over the place. So they said that Juror 50 and the media had done something wrong, that his conduct would be subject to scrutiny, and that the conduct was serious enough to warrant the appointment of a lawyer. And we read that. We go, oh no, because the prosecutors have to submit this to the court because they now know about it. Had Ms. Maxwell been asked, she would have objected to the public filing of this letter. So not only did they screw their case up, and not only did you contribute to the messing of this case up, but also you have screwed up the fixing of this problem by allowing the public filing of documents that nobody even asked us about. So when the prosecutor alerted the court of this problem, they also broke some rules. So we're going to have to really ask for even more penalties. And so there's even more reasons why you should give us a new trial. The government knows how to file a letter under seal. This court's protocol throughout this case has been for parties to file letters under seal and then place restrictions on the document, and they didn't do that. Wonder why that might be. The 5th juror's false question answer to 48 was not a one-off mistake. He also lied on question 25. Then during voir dire, he claimed that he deleted his social media accounts, and he didn't. This is a false pattern. This is a pattern of false answers. And then lastly, this case is not like other cases where a juror may have given a false answer to avoid embarrassment, all right? Juror 50 ran out there and talked to numerous media outlets about his service, admitted that he was a victim of this stuff, and then didn't even attempt to conceal his identity. He allowed himself to be identified, publicly recorded, was just out there soaking it up. He reveled in it, they write. So this is different than somebody wanting to keep this under seal. I'm going to lie about my history because I don't want anybody to know about it. And I'm going to keep this buried for the rest of my life. You might say, okay, I can understand that. That's not what happened here. He apparently, according to the defense, hid it and then went out and talked all about it. Why? So he could get on the panel to invoke justice. Had Juror 50 answered these honestly, we would have explored the rest of this. Pretty obvious. They would have, let's see here. The court emphasized the importance of voir dire, said that it could smoke out jurors who did not tell the truth. So it sounds like Judge Allison Nathan said, I'll handle the voir dire. I can smoke out these jurors who are being dishonest. Yikes. Says here, apparently the judge says this, I will individually one-on-one question the jurors, and with the parties present, I feel confident that I can discern any clear dishonesty. Judge Allison Nathan says this is not just going to be a summary voir dire. It will be probing. If a juror is going to lie and be dishonest, we will smoke that out, said the judge. And apparently, the defense, as we saw earlier, they wanted to ask some of these questions too. They're like, well, that's nice, Judge, but we don't really think that you're too good at this thing. Like, we're better at asking questions and smoking out the people who might be dishonest. Do you think we can ask some questions? Oh, no, we're good. I got it. No problem. And the questions that they would have asked would have actually smoked out the jurors. Judge couldn't get it. Because Juror 50 did not answer these material questions, the court and the defense were not alerted to these issues. And in hindsight, that claim is not credible. They say this is not speculation. The Juror 50 went and said this to the media. It's clear that he was not fair. He said that his personal experiences prevented or substantially impaired the performance of his duties. And they're referencing a U.S. Supreme Court case here. If Juror 50 had been honest and disclosed that he was a victim here, we could have asked other things. The court and the parties could have probed, and they could have assessed they could have asked him, sir, are you able to assess the credibility of all of the victims here, just like any other witnesses, or are you going to give them more benefit of the doubt? Because you personally identify with them, are you going to give them an extra 10% believability? Plus 5 credibility for the victims, or no? To fairly evaluate the testimony of Dr. Loftus, and to impartially asking whether he was able to do those things, to impartially assess Maxwell's defense in context, and to set aside his own traumatic experiences, and to evaluate the government's case. Juror 50 failed to disclose those things, and doing so was problematic. We know that he lied about another false answer during voir dire, falsely said he was on social media when he wasn't. He gave several material misstatements, they write. Proper voir dire plays a role, Sixth Amendment, federal rules of criminal procedure, peremptory strikes, the scope of any evidentiary hearing as they're talking about. They want another hearing itself. They say Maxwell requests that any hearing begin with the questioning of Juror 50. They say that they want the court to advise Juror 50 about the nature of the hearing and allow defense counsel to question Juror 50 following the question from the government, recrossed by defense, followed by questions from the court, and then other questions and questions. So they want to put him on the stand and just go at him. And currently, we have not seen that. Remember, he was called into court, but the judge asked him the questions. It wasn't a prosecutor defense back and forth. The defense wants to ask him a ton of questions. They say, if after this examination further inquiry is required, we suggest, Maxwell does, that the second juror, whoever that happens to be, also comes back here for a same process. If necessary, we should do this for all the jurors until we smoke out once and for all what really happened here. After examination of the jurors, the party should be afforded time to conduct further investigation. Rules say we can do this stuff. They say Juror 50 has no right to intervene. He lacks standing. This court should basically treat him as somebody under investigation. He's not a party to this. Refuse to give him discovery. You can see discovery would be sort of files on this case saying that he's not entitled to these things, saying that his filing should be stricken or remain under seal. And you can see we're getting close to a conclusion here. Second Circuit has given us some opinions on that. We finally get to a conclusion. The purpose of voir dire is to expose bias and prejudice on the part of the venirement. We have here, there must be sufficient information elicited on voir dire to permit a defendant to intelligently exercise not only his challenges for cause, but also his peremptory challenges. And they didn't get an opportunity to do that. They say this court expressed confidence that it could smoke out a juror that was dishonest, but they didn't. We know that Juror 50 was at least one that did not honor their obligations to give truthful answers. And because Maxwell's jury was not fair and impartial, this court should vacate the jury's verdict and order a new trial. In the alternative, this court should hold an evidentiary hearing and examine all 12 jurors. Now you can see this was filed some time ago. January 19, 2020. We are just now getting it filed with the court March 11th. And we're going to see that this was sent over to all the prosecutors who were involved here. Allison Moe, that was Maureen Comey's daughter of James Comey. Allison Moe, Andrew Rohrbach, Laura Pomerantz over at the U.S. Attorney's Office. And that is the certificate of service, the final page of page 66. Whew, that is a big motion for a new trial. And so we can see they've conducted one hearing with this juror number 50, and Scotty David answered some questions. We talked about those. Now, several of the questions that were brought up here in this motion for a new trial, sounds like they weren't addressed or asked at the original hearing where Scotty David was called back into court for that line of questioning. And we haven't seen anything showing that they're going to be doing another set of questions with that other prospective juror. But we are waiting to hear back from the judge. And there's going to be a lot more that comes out of this case. Ghislaine Maxwell, is she going to get a new trial? I mean, if these things were as consequential or as catastrophic as their defense team is arguing, that is a problem. We might have to do this whole thing over again. What do you think? Let me know down in the comments below. Don't forget to stick around and subscribe. We have a mind map on this case. And so feel free to find that in the description if you want to poke around the majestical web of disgusting creatures, then you can do that. Ghislaine Maxwell, of course, still sitting in custody. Many of the people who use Ghislaine Maxwell services, they're still out there roaming around as this case continues to sort of do the slow roll. Many people perfectly satisfied that Ghislaine Maxwell has been convicted and then kind of resting assured and sleeping soundly at night, knowing that she's never going to walk free, but she might. Let me know what you think. And don't forget to subscribe, stick around. I look forward to seeing you on the next one.